I'd like to talk to you about advanced directives and do not resuscitate orders. This is a universal topic for us all. It affects all our lives. My talk is geared towards doctors, nurses, and healthcare professionals. I have no disclosures. I am Barry Miskin. I'm a surgeon here at Jupiter Medical Center and also a hospice physician as well for Trustbridge. I'm board certified in surgery and also board certified in hospice and palliative care. Upon completion of this program, hopefully you'll be able to define ethical principles that guide advanced directives, identify different types of advanced directives, define the DNR order, but most important of all, identify ways that you can guide people to put together their advanced directives and how you can guide those conversations. There is a great deal of uncertainty in life, especially now with a worldwide pandemic, the turmoil in the world, recent collapse of that condominium in Miami. One of the greatest gifts that we could give our loved ones, our significant others, would be our choices and how we would want to be treated if we had a serious illness or a medical emergency that involved ourselves. It's such a difficult struggle, and I see this all the time where families have to decide the fate of their loved ones and they're never really truly certain what they would have wanted. So this is something I think that is universal and speaks to us all. Healthcare decisions are never easy, especially for ourselves, but also to guide our patients to make the best decision. Making informed choices comes with an understanding of the possible care and treatments and the risks and benefits if our patient or ourselves are afflicted with serious illness or any medical emergencies. The following information you will get hopefully will guide you as healthcare professionals in being able to better guide your patients and also better guide yourselves and your families in considerations regarding your end-of-life choices. These are the four important ethical principles guiding advanced directives. Autonomy. This is the right of the individual to self-determination, the right to self-govern. This is based on the individual's capacity to understand the consequences of their decision and having the capacity to make healthcare decisions and provide informed consent. Autonomy is respecting a person's right to maintain control over decisions. Do good, beneficence, maximizing comfort. This refers to the concept of doing good as a basic tenet of healthcare. Doing good is the concept of weighing the benefits and risks or burdens against doing harm. It implies that not only should we refrain from harming the individual, but we should also contribute to their welfare. Doing good may be dependent upon perspective to the individual based on culture, personal experience, and background. Do no harm, non-malfeasance, minimizing harm. This is the concept that refers to the obligation to do no harm or minimize harm based on risks and benefits of treatment. Healthcare teams must always consider this ethical tenet as a guiding principle. However, this concept is not always clear and depends on the context. It's important to consider that minimizing harm is a concept that can be reviewed in different aspects depending upon the perspective and lens of the party involved. What one may consider harmful by one person may not be harmful to another. Cultural, spiritual, and religious values may come into play. Substituted judgment. This represents the wishes of an incapacitated person. There are three sides to every story, and everybody has a different view of reality, and their beliefs are their reality. I work in a trauma center. I see very severe head injuries, and there is no hope for recovery, flat EEG. We just recently had a young fellow who had a trailer behind him. He stopped short, and the trailer hitch went through the back window and through the back of his brain. There was no hope for recovery, but he was on a ventilator and breathing. The medical team felt that the best plan was to withdraw artificial intervention and to take him off the ventilator. The family thought this was harmful and had a different understanding with their cultural and religious values. There's a lot of these situations that we see. One of the best examples in American culture was the Terri Schiavo case. I think it would be good to talk about the Terri Schiavo case. If she had had an advance directive in place, a lot of things would have been a lot easier for her husband and her family. She was born in 1963 in Philadelphia as Teresa Marie Schindler. She struggled with obesity since she was a young child. She eventually lost 100 out of 250 pounds. In the morning of February 25, 1990, Terri Schiavo collapsed in the hallway of her St. Petersburg, Florida apartment. Firefighters and paramedics arrived in response to her husband Michael's 911 call. They found her face down and unconscious. She wasn't breathing and she didn't have a pulse. They attempted to resuscitate her. They intubated her and ventilated her, and the paramedics took her to Humana Northside Hospital. The cause of Terri Schiavo's collapse was determined to be cardiac arrest. The cause of her cardiac arrest, according to her medical records, was most likely her potassium at 2. From drinking liquid, she diluted herself down. Because of this, a year later, the findings of two physicians, her family physician and a neurologist, determined that she was in a persistent vegetative state after a year after her sudden cardiac arrest. From 1990 to 93, Michael Schiavo, her husband, and the Schindlers, Terri's parents, enjoyed an amicable relationship, with the Schindlers allowing Michael to even live rent-free in their condominium for several months. In 1992, Michael filed a malpractice suit against Terri's gynecologist. He felt that the gynecologist failed to diagnose bulimia as the cause of her infertility. Terri had gone to the doctor because she had stopped menstruating, but the doctor failed to take her medical history into account, which might have revealed an eating disorder. During the case, one of Terri's friends even testified that she knew Schiavo was bulimic. In November 92, Michael won the case and was awarded $6.8 million by the jury. It was later reduced to $2 million as Terri was found partly at fault for her condition. After attorney fees and other expenses, Michael received $300,000 and $750,000 was put in a trust fund for Terri's medical care. According to Michael, in the early 2003, the Schindlers demanded that he share the malpractice money with them. On June 18, 1990, the court appointed Michael Schiavo as Terri's legal guardian, wanted the feeding tube removed. This was disputed by her parents, the Schindlers. In May 98, Michael Schindler filed a petition to remove the tube, which her parents opposed. A court-appointed second guardian, Richard Pierce, reviewed it, and he noted that there was no possibility of improvement, but Michael Schiavo's decision might have been influenced by the potential to inherit what remained of Terri Schiavo's estate, as long as he remained married to her. Due to a lack of a living will and questions regarding Michael's credibility, Pierce recommended denying the petition to remove the feeding tube. Pierce reported that the issue of conflict of interest applied to her parents as well. Had Michael divorced Terri as they wanted to, they would have inherited the remainder of Mrs. Schiavo's estate upon her death. This is some of the background information that I think a lot of us did not realize that sort of tainted this case. This took me a few minutes to figure out, but these are big spoons. But the point being here is that Terri didn't have a living will, and nobody could really say exactly what her choices were for her end of life. Pinellas County Judge Greer, during the week of January 24, 2000, determined that Terri Schiavo's wishes would have been regarding life-prolonging procedures and issued his order granting the petition for authorization to discontinue artificial life support for Terri Schiavo in February 2000. So oral feedings and a second guardianship challenged in March 2000. The Schindlers filed a motion to permit assisted feeding at Terri, which is not considered a life-prolonging procedure under Florida law. And then they had multiple petitions and hearings ensued, and it just turned into one big legal mess. Finally, October 15, 2003, Schiavo's feeding tube was removed. Within a week, the Schindlers' final appeal was exhausted, so State Representative Frank Atkinson and the Florida legislature passed Terry's Law. It was an emergency session giving Governor Jeb Bush the authority to intervene in the case. Governor Bush immediately ordered the feeding tube reinserted. He sent the Florida Department of Law Enforcement to remove Shivo from the hospice. She was taken to Morton Plant Rehab Hospital in Clearwater, where her feeding tube was then surgically reinserted, and then she was returned to hospice. Michael Shivo opposed the governor's intervention in the Shivo case, and in part was represented by the ACLU. At the same time, her parents, Robert and Mary Schindler, attempted to intervene and participate in the Terry Law case. This was denied by Judge Bard, a circuit judge in the Florida 6th Court. They appealed on February 13th and ordered Bard to hold further hearings on the issue. Bard denied the Schindlers the right to intervene a second time. The Schindlers, represented by the American Center for Law and Justice, appealed the right to participate in the Terry Law case. May 5th, 2004, Judge Bard found Terry's Law unconstitutional and struck it down. Governor Bush appealed this order, sending it directly to the Florida Supreme Court. The Florida Supreme Court then overturned the law as unconstitutional. So they anticipated that this was not going to pass, and then this gets even crazier. President George Bush calls a special session of Congress, and he has a bill that's passed March 20th, 2005 by the Senate by unanimous vote, passing a relief bill. Since the vote was taken by voice vote, there's no official tally. The bill transferred jurisdiction of the Shivo case to the federal courts. The bill passed the House on March 21st, 2005 at 12:41 a.m. Bush flew into D.C. from his vacation home in Texas, and he signed it, the law. As in the state court, all the Schindlers' federal petition and appeals were denied, and the U.S. Supreme Court declined to stop the removal of the feeding tube, effectively ending the Schindler judicial options. Terry Schindler died at the Pinellas Park Hospice on March 31st, 2005, and this was the end of a milestone case. Terry Shivo's parents had different values than her husband, Michael Shivo, and maybe even different values than her. How you approach something is different depending on how you're brought up, what you think, what the meaning of life is to you, what your thoughts are and feelings, and how old you are. You look at something different at age 40 than you do at 85. These types of situations tend to change, and so does your instruction about them. You could be flexible. As you get older, your viewpoint and your feelings about what you want to have done changes. This brings us to our next important case, the Karen Quinlan case. This case changed everything. This is the first case that gave the right to die and gave a different direction for advanced directives. In 1975, shortly after Karen Quinlan turned 21, she left her parents' home and moved in with two roommates into a house a few miles away. At the same time, she went on a radical diet, reportedly to fit into a new dress that she bought. On April 15, 1975, a few days after moving into her new house with her new roommate, she attended a friend's birthday party at a local bar. It was known as the Falconeers Lackawanna Inn on Lake Lackawanna in Byram, New Jersey. She'd eaten almost nothing for 2 days. At the party, she was seen drinking several gin and tonics and taking Valium. Shortly after, she felt faint, was quickly taken home by her roommates and put to bed. When friends checked on her about 15 minutes later, they found that she wasn't breathing. An ambulance was called and mouth-to-mouth resuscitation was attempted. Eventually, some color returned to her skin, but she did not regain consciousness. A little background on Karen Ann Quinlan that was important. She was born in Scranton, Pennsylvania, March 29, 1954, to an unmarried woman of Irish-American ancestry. A few weeks later, she was adopted by Joseph and Julia Quinlan. They were both devout Roman Catholics who lived in New Jersey. They also had a daughter, Mary Ellen, and a son, John. From 72 to 74, Karen Ann Quinlan worked many jobs, but her dream was to become a singer. April 75 is when she turned 21, moved out, and went to that birthday party that night at the bar. She suffered irreversible brain damage. She experienced an extended period of respiratory failure, and it lasted 15 to 20 minutes. There wasn't any type of precise cause of her respiratory failure that had ever been given besides the Valium and the alcohol. Her brain was damaged to the extent that she was diagnosed as having a persistent vegetative state. Karen Ann Quinlan was at this point on a ventilator because of her anoxic brain injury. Her parents wanted the ventilator disconnected, and they approached the hospital. The hospital was then threatened by the Morris County, New Jersey prosecutor for homicide charges. They felt that this was murder if they took her off the ventilator. Her parents, the Quinlans, filed a lawsuit on September 12, 1975 to request extraordinary means prolonging Karen Ann Quinlan's life be terminated. The lawyers argued, but the state told them that this was going to be a homicide case if she was taken off of life support. Also, they felt that the doctors did not feel that she should be removed from life support because it was a medical decision. The doctors were threatened as well by the prosecutors for homicide charges, so they refused the parents' request to disconnect the ventilator. So this was a mess. The Quinlans did appeal, and they ended up in the New Jersey Supreme Court, and finally on March 31st, 1976, the court granted their request, and they held up the right to privacy was broad enough to encompass the Quinlans' request on Karen Ann Quinlan's behalf, and she was removed from the ventilator. Karen's ventilator was finally removed on May 76, and she didn't die. She continued to survive. The parents never asked for the feeding tube removed, and she was moved to a nursing home. She was fed by artificial nutrition for 9 more years until her respiratory death on June 11th in 1985. Her parents started a foundation and opened a hospice and a memorial fund in her name in 1980 to honor her. But the important thing about Karen Ann Quinlan is she started this movement for living wills and right to die. And the first state to do this was in 1976, was California. And this is largely as a result of this case. It's considered the first right to die case, with social awareness being raised and movements springing up throughout the country. Now, by 1992, all 50 states had passed living will legislation, and today, thanks to this, advanced directives are available for all of us so we could have what we would consider a comfortable or natural death. I would just like to go over one more important case. January 11th, 1983, 25-year-old Nancy Cruzan lost control of her car at night in Carthage, Missouri. She was thrown from the vehicle, landed face down in a water-filled ditch. The paramedics found her. She didn't have any vital signs. She was resuscitated, and after 3 weeks in a coma, she was diagnosed with persistent vegetative state. Surgeons inserted a feeding tube for her long-term care, and her story began. In 1988, Cruzan's parents asked her doctors to remove the feeding tube. The hospital refused to do so without a court order, since removal of the tube would cause her death. Nancy's parents filed and received a court order to remove the feeding tube, and it was felt by the court that this is a fundamental natural right, especially when there's no hope for further recovery. The patient has no cognitive brain function. Well, the state of Missouri and her guardian ad litem, appointed by the courts, both appealed the decision, and the Supreme Court of Missouri reversed it and said that you can't refuse treatment for another person, especially if they don't have a living will. And this was inherently reliable evidence that there was no living will and that she had not made any wishes prior to her accident. So her parents did not stop. They appealed the case in 1989, and they took it to the Supreme Court of the United States. The issue in the case is whether the state can order a person to receive invasive medical treatment when the order is contrary to the wishes of the family, when it overrides all available evidence about the person's wishes prior to the accident, and when the decision to forgo treatment is among acceptable medical alternatives. And the 14th Amendment guarantees these liberties, so the Supreme Court ruled in favor of the family. Nancy Cruzan's family gathered more evidence that showed that Nancy would have wanted her life support terminated. So the state of Missouri withdrew their case September 1990, and they were allowed to remove the feeding tube. Nancy died December 26, 1990. Because of this case, law of 1990, Patient Self-Determination Act, was passed by the federal government. Basically, it's ethical principles of substituted judgment of close friends and family could speak for the patient's wishes in absence of a written court directive. Also, the court found that feeding tubes were regarded as artificial life support like ventilators, and people had the right to refuse or withdraw artificial feeding according to their wishes. This is a picture of a feeding tube in an ALS patient, and this is something that we see a lot. It's basically a milestone in treatment of ALS patients. We just had one recently in hospice who was a young woman. She was 40, and she just could not swallow anymore and decided to forego the feeding tube. So it's a major decision for people, and something that you probably want to put in your advanced directives, whether you want a feeding tube, if you think it'll sustain you if you're in a vegetative state. There's a lot of options, and we'll talk about that in the next few slides. These look like lunch boxes for kids, but they're not. They're basically pouches for feeding tubes, for enteral nutrition, and for tube feeds. So things are not as simple as you think, and there's a lot of variables to any type of decision that you make for yourself, for your children, for somebody else's children, or for your patients. Thanks to the family of Karen Ann Quinlan and her husband, we have the California Living Wills Act, which now is something that's seen in all 50 states. They passed living will legislation. And thanks to Nancy Cruzan and her family, we have a Patient Self-Determination Act, which is a federal law. And basically, because of these pieces of legislation, we can have advanced care plans and living wills for ourselves and for our patients. We're now going to talk about advanced directives, and we'll get more into detail with this. Your advance directive is just a simple written statement that's made in advance of any type of serious illness or injury, and it's in front of witnesses. And it basically indicates the person's choices, your patient's choices, or your choices for future health care decisions if you're in certain types of situations that you can't make the choice yourself. So the good news here, if there is good news, is your advance directives never expire and you don't need a notary to do them. Your advance directives can always be changed. You can change them verbally, you can just cancel it, you can take it with you when you travel, and it'll usually generally be accepted in other states. And if you move out of state permanently, you have to make sure that you just look at the state laws where you're at to see if these would be respected or what you need to do to change it. But in Florida, we generally respect advance directives from other states. There are specific types of advance directives, and they include your living will, an appointment of a healthcare surrogate, your power of attorney for your healthcare, and organ donation. This is an example of a living will, and it's a binding legal document. It basically puts down on paper your choices about different treatments that you would want, and when you're not conscious or you're in an accident or something has happened where you can't make these decisions. And these kind of treatments that would be in this type of living will would be things like blood transfusions, CPR, feeding tubes, dialysis, respirators, different types of things like that. It's a legally binding document unless it's not witnessed properly, and you need to have 2 witnesses to sign this. A living will lets you document your choices. When you can't communicate them, your wishes are down on paper. If you're in some type of end-stage medical disease or persistent vegetative state or in a bad accident, people can look at your living will and know what you want. They don't have to make the decisions for you. A living will simply states a person's end-of-life care wishes. And a physician, interestingly enough, cannot be sued or prosecuted for following somebody's living will. It's important that it's signed by 2 competent adult witnesses. A living will is not the same as a DNR. A DNR is an order. The important thing with the living will is you have to have 2 witnesses that aren't blood relatives, that are not healthcare staff, and that or don't have any type of relationship with you. You don't need an attorney to do this, and you don't have to have this notarized, but you do need 2 witnesses. And they cannot, again, be blood relatives or a spouse. So healthcare surrogate is based on the principle of substituted judgment. You have another person making healthcare decisions for you. And this could be your daughter, son, or cousin, or it could be all 3. A lot of times it's better to have one specific person. We see a lot of times that all the kids, all 5 of them, are the healthcare surrogates, and it creates a lot of confusion, especially when somebody has to come up with a decision pretty quick about your healthcare. Also, something like this, you can have it in effect whether you have capacity or not. You need to have this all written down. So it's important that you can make really good care decisions. Good take-home point and thing to remember is to make sure you tell your healthcare surrogate that they are your healthcare surrogate and the responsibilities that they do have. Also, again, the healthcare surrogate cannot be a witness on your living will document. You don't need an attorney to complete your healthcare surrogate designation, and you don't have to have it notarized. It's important to have an alternate, too, in case something happens to your healthcare surrogate or they can't be found at the time that they're needed. And it's important to let that alternate know their duties and that you're picking them. Capacity and competency. These are like 2 really, really important concepts. Capacity is determined by a doctor, competency by a judge. And with capacity, this person lacks capacity. This is assessed by a physician. And during this period, the person can't understand information, make a decision, drive a car, or communicate. And hopefully this is just a temporary state for this person. Competencies, sometimes called legal capacity, and this is a judge's decision. It's not made by a doctor. Sometimes the judge may ask for some medical input from a psychiatrist, a psychologist, or physicians, but basically it's multiple areas of competency can be usually addressed in a legal setting, such as competency to stand trial, make a will, be a parent, and end stage or late stage dementia, I think, is a good example of this. This is an example of a healthcare surrogate form. The power of attorney is a legal document that allows someone to act on your behalf, and the power of attorney can be helpful to older people and others who choose to have a trusted person to act when they can't. The power of attorney is typically while you lack capacity, and it could be a temporary thing, where a durable power of attorney is regardless of your capacity, and it's typically financial but may include also healthcare surrogate, as well as the power of attorney may also include healthcare surrogate. And there's no legal requirement that you have a lawyer prepare or review it. However, if you're going to give important powers to an agent, it's sort of wise to have some type of legal counsel. With this power of attorney, an agent can sign the checks for the principal, withdraw, deposit funds from the principal's financial account, change or create beneficiary designations for financial assets, and perform many other financial transactions. Again, your healthcare surrogate determines your healthcare situations. So if you haven't thought ahead and you lack capacity, there's a hierarchy with Florida law and specifies a sequence of specific people that would become your healthcare decision maker. And the person's called a healthcare proxy, and the sequence of hierarchy is called the proxy tree. The healthcare proxy is a competent adult who's not been expressly designated to make healthcare decisions for a particular incapacitated individual, but is authorized as per Florida proxy statute to make healthcare decisions for the patient. Competent adult is defined many ways. I thought this was pretty good. The 11 skills that you need is: can you accept criticism? Can you negotiate? Can you ask for help? Can you cook? These are just a few. Can you manage your time? But I think the one that resonated the most is: can you say no? This is designated by Florida statute appointing a healthcare proxy, but it makes sense. It's either a relative, your spouse, a child for a parent, or a parent for a child, or if not, a guardian, and the court is involved. A licensed clinical social worker or a graduate of a court-approved guardianship program can also be a healthcare proxy. If you choose to donate organs or your body at the time of death, the state of Florida has a uniform donor form that allows you to document this. You have to, again, have 2 adult witnesses. You don't need an attorney for this either. You can also make the decision on your Florida driver's license that shows you're an organ donor. There's 120,000 people in the country currently that need organs, and there's only 47% of people are enrolled in organ donor programs. This is never an easy conversation when you are discussing advanced care directives. It's uncomfortable for a lot of people. You have to be very empathetic, and you have to understand people's goals and agendas. This is so important that there's actually a CPT code for advanced care planning that's reimbursed to physicians. And here's the codes. It's important to communicate your life choices, or have your patients communicate their life choices, to let their family and their doctors know what they want, and to keep copies of advanced directives in easily accessible places, and to take copies to the hospital if they're admitted. Advanced care planning discussions are difficult discussions. It's difficult to know exactly what the patient knows. You want to be sensitive to their spiritual, religious, and cultural beliefs. Life and death mean different things among different ethnic and cultural groups, and it's important to take all this into consideration when you're having these discussions. Quality of life is subjective. Someone pulling a rickshaw through the slums of Bombay may be happier than a billionaire in Palm Beach. Everything is relative. It's good to ask open-ended questions and to make this not about us. and to try to guide people so that they have the best advanced directives and the best end-of-life plan. 65 is an important number. 65% of adults in the U.S. use social media. 65% of people who died had healthcare surrogates. 65% of people who died also had living wills. This is all according to national statistics. 30% is another important number. The Minnesota Golf Association reported there was a 30% increase in rounds of golf played in 2020. Also, of the 65% of the people per national statistics that had living wills, only 30% could be found in the chart. 34 is another important number. Nissan purchased 34% of Mitsubishi Motor shares. Also, 65% of people who died had healthcare surrogates. Only 34% were available in the charts that the hospitals documented. Which leads us to our next point. Are your advanced directives accessible? What good is having them if people can't find them or they can't figure out who your healthcare surrogate is? This is another issue that we see a lot of in hospice. If your choices can't be found, your wishes may not be known. Let's talk about do not resuscitate orders. The state of Florida recognizes out-of-state advanced directives. An out-of-state DNR, though, for EMS is a doctor's order and it's not accepted in Florida. And this is not accepted either. A living will doesn't substitute as a DNR. A living will just instructs your healthcare team about your choices. A DNR is the only portable doctor's order. It can go with you from place to place. It's state-specific. State of Florida DNR form is the only document addressing resuscitative efforts that is recognized by the emergency medical personnel. A DNR can be signed by a legal representative if the person's incapacitated. It's also in Spanish, Creole, and other languages. It must be accessible at all times. For home hospice, we ask them to put it on the refrigerator door so it's easier in case EMS comes. I'm sure most of you are familiar with this, but this is a picture of the state of Florida do not resuscitate form. We say allow natural death instead of do not resuscitate. I think it has a better meaning. I think the most common myth with the DNR is once you sign it, nobody's going to treat you. I think a lot of people truly believe that. Again, communication's so important. It's important to define and clarify these terms. So, in summary, as we discussed, the advanced directives in DNR are based on the ethical principles of autonomy, beneficence, non-malfeasance, and substituted judgment. Advanced directives include all this: living will, appointment of a healthcare surrogate, power of attorney for healthcare, and organ donation. Again, the DNR is a physician's order. It must be printed on yellow paper for EMS, and without a DNR, EMS must use all interventions available to resuscitate. Without advanced directives, the hierarchy of the proxy tree must be followed. You should always read patients' advanced directives, and you should always consider completing our own advanced directives or our families so that everybody will know our wishes. Thank you so much for your time and attention. These are a list of references I used to create this talk that I hope is helpful for you, your family, and your patients. Thank you again.